Like, you just thought that all the other judges missed this power for the last 200 years and no other judge could have, issued an injunction against somebody in the Civil War era? Actually, no. We observe only this. Justice Jackson decries an imperial executive while embracing imperial judiciary. Dang, son! With its ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny this. Wild. In the Supreme Court of the United States, we have the case Trump and CASA. You remember CASA, one of these organizations that supports migrants invading our country, as they call it. And now the Supreme Court is going to be ruling not on the merits of the birthright citizenship issue. So not exactly what does the 14th Amendment say? Does it say what does subject to the jurisdiction mean? Does it mean that if you're here as a lawful resident that applies? Does it mean if you're here illegally, does it apply? It's not there yet. We're talking about the injunctions. And what has happened is we've been covering here all these past few months are lawsuits that have been filed by ACLU people and democracy defenders and Norm Eisen's groups and Mark Elias's groups and all the rest of them, suing in favorable jurisdictions, shopping for a forum, going, we're going to go find Judge Zenas. We're going to go find Judge Boasberg. We know that our clients are being detained in Texas, for example, and that we should be filing in Texas, but we don't like the Texas judges because they're going to say we lose. So we're going to go to Maryland. We're going to go to Washington. We're going to go to California. We're going to go to DC in front of Boasberg. And then those judges grant these nationwide injunctions that say that they're successful and that Trump is stopped. Same pattern happened in this case. CASA said, you cannot, Trump, issue an executive order that eliminates birthright citizenship. And America is one of maybe the only countries in the world that still allows this, where you just come in, plop a baby, even if you're here illegally. In other words, you violated the law. You've broken the sovereignty of the country to come in here and have a kid. And that kid gets the benefit of your unlawfulness? What kind of insanity is that? And this comes back to the 14th Amendment, passed during the aftermath of the Civil War and the Reconstruction Amendments. And we're now in the Supreme Court. Now, the decision came out, it was 6-3. And what's curious about this is one of the judges who was in the dissent, who is named Justice Kagan, she said this a long time ago. In fact, Town Hall clipped this back in May 15, 2025. One of the dissenters, Justice Kagan, back on September 14, 2022, so not that long ago, she should remember this. She's now disagreeing with the majority, but this is what she said some time ago when talking about these universal nationwide injunctions that allow one district level judge in some district, like Northern District of California, now issues an order that stops the entire country from operating under the duly elected president's authority. Here's what Kagan said when judges did that.
It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through a normal process.
Yeah, pretty shocking that happens. And since Trump is now in the White House, guess what? It happened. And she said that back during 2022. Of course, that's when Biden was in office. So when judges were injuncting Biden, Judge Kagan comes out and says, we can't do this. Then suddenly, when Trump's in office, she joins the dissent. All right, just to be clear on where these people are. Now, here is the decision. Judge Amy Coney Barrett, who we suddenly like again, she came out and delivered the opinion of the court, and she went hard, and she was not playing around with Ketanji and her little dissent. The United States, Trump has filed 3 emergency applications challenging the scope of a federal court's authority to stop government officials from enforcing an executive order, right? Trump's knocking on our door 3 times, says Amy. Now, traditionally, courts issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs in the lawsuit. Now, the injunctions before us today, says Amy, reflect a more recent development. In fact, it's gotten even worse. District courts asserting the power to prohibit enforcement of a law against anyone. Now, these injunctions, known as universal injunctions, meaning anyone not in front of the court, just the whole country, likely exceed the equitable authority that Congress has granted to federal courts. Now, we therefore grant Trump's applications to partially stay the injunction that was issued below. Now, the injunction in the case below was about the 14th Amendment and about how Trump could not enforce the 14th Amendment and the administration's interpretation of the Citizenship Clause, which is subject to the jurisdiction thereof. Now, the applications before us concern 3 overlapping universal preliminary injunctions that came out. This one out of Maryland, California, and Washington. Now, these individuals or organizations and states, they came in to stop Trump's executive order. This was protecting the meaning and the value of citizenship. And the executive order identifies circumstances where specifically, subject to the jurisdiction thereof, where it applies and where it does not, in conjunction and in alignment with American law. Specifically, Trump's executive order set forth the policy of the United States that we are no longer going to accept documentation of citizenship in two situations. One, when a person's mother was unlawfully present in the United States and the father is not a citizen or lawful permanent resident at the time of the person's birth. Okay, mom's here illegally and dad is not a citizen or lawfully here. Baby, your parents are here in our country illegally. We're sorry they had you here, but their illegalities do not transmute into a benefit for this little baby. And so they're going to come out, and this is always, you want to deport babies? Yes! Their parents broke the law. We can't care for the babies. So when the parents get deported, the babies go with them because we don't want to be in custody of foreign citizened babies. Now, when a person's mother's presence in the United States was lawful, but temporary, and the person's father was not a United States citizen either, right? So this is for people who are here on visas. Temporarily. You're here temporarily. It's not permanent. So you don't get to have a child who's an automatic citizen. Other countries don't do that. The executive order also provides for a 30-day ramp-up period. Now, during that time, the order directs executive agencies, and Pam Bondi got asked about this, to develop and issue guidance regarding the order's implementation. Well, how's it going to work at a hospital? Like, who's checking that? Are you not going to issue social security numbers when it comes up to the federal government level? What's the status? So what they did is they sued. They said, you can't do this. The 14th Amendment says that we have a right here. Now, in each case, the district court concluded that Trump is likely unlawful in his executive order. And all three of these maniac judges issued a preliminary injunction barring various executive officials from applying the policy to anyone in the country. Okay, anyone. Not the people who sued, everyone. So that is like a judge acting like a congressperson, dictator kind of situation to issue a rule that impacts everybody. Do we elect him to be like a dictator or she? No, it's limited to cases and controversy. It's in the Constitution, in fact, and the judges just didn't care because they said, well, for benefits and due process and illegal, and if it's illegal here, it's got to be illegal everywhere and all the things. The Supreme Court today said no. The government has now filed 3 nearly identical applications, right? Third one's the ticket, I guess. The applications do not raise, and thus we do not address the question, which is this: whether the executive order violates the Citizenship Clause or the Nationality Act, right? So we're not going to get to the merits of it. What does subject to the jurisdiction thereof mean? Not there yet. Well, we'll come back, as Bondi said, next session. The issue before us is one of remedy. Does the Judiciary Act of 1789, which created our courts and federal courts, do they have this authority to issue universal injunctions? Answer coming up. The question, whether Congress has granted this authority, warrants our review. And so we'll do it now, writes Amy Coney Barrett. We've talked about this a lot. Gorsuch wrote about it in this other case. Gorsuch was whining about it. He's like, I would also, in this other case, which they didn't decide, he's like, I would have decided that one there too. He also said it again in this case. He's like, we should fix it here. Kavanaugh said, we should fix it here. And on multiple occasions across multiple administrations, the Solicitor General has asked us, multiple administrations have said, what can you do about this expansive remedy? We even heard Kagan was just complaining about it when her dude was in charge. We can't have this happening because it's unconstitutional. It's ridiculous. It doesn't make any sense. How is it in alignment with our democratic republic where we have representatives who represent a constituency of people? It's not. It's one judge acting like he runs the whole country. Not anymore. Now, it's easy to see why. By the end of the Biden administration, we had reached a state of affairs where almost every major presidential act was immediately frozen. And the trend has continued. During the first 100 days of the second Trump administration, district courts issued 25 universal injunctions on all of these policies. Congressional Research Service explained it. Now, as the number of universal injunctions has increased, so too has the importance of the issue. The government now is likely to win because it's insane. A universal injunction can be justified only as an exercise of equitable authority. Yet Congress has granted federal courts no such power. So where'd they get it from? Jeb, Zenas, Murphy? Oh yeah, from your booties. The Judiciary Act of 1789 endowed federal courts with this. All suits, even those arising in equity. And still today, the statute is what authorizes the federal courts to issue those equitable remedies. Now, though flexible, this equitable authority is not freewheeling. You can't just do whatever you want with it, It still comes from the statutes. Now, we have held that the statutory grant encompasses only those sorts of equitable remedies like an injunction or an order of, payment of monetary damages or whatever. What are those? They are the same powers that happened that we had at our country's inception. All right, so the powers that they passed back in 1789 are still those same powers, unless the law changes those powers. Now, they've suddenly expanded and inflated, like everything in our system, and become more meaningless with the inflation of the power. And now Amy is saying, you can't actually do that, okay? It's the same as it was when we were in the founding era. Explaining. Question when it comes up. What is the power? Can we allow federal courts to issue nationwide injunctions? She says. The answer is no. Neither the universal injunction nor any analogous form of relief was allowed back then during the Court of Chancery in England. Now, they did have a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing processes of law. Now, eventually, the Crown instituted the practice of delegating the cases, and they went to the Chancellor. Like, the case came in, you go, okay, who's got the problems here? This party over here, like this party over here, a little Judge Judy action. Of importance here, suits in equity were brought by and against individual parties. Indeed, the general rule of equity was that all persons materially interested are actually parties to the case. Shocking and obvious. Nor did the founding era courts allow a different course, right? You had to actually have a connection. You had to be a party to the lawsuit. Even the English got it. Judge Boasberg can't figure it out, but they got it back in, the 1600s. In ensuing decades, we consistently rebuffed requests for any relief that went outside of the parties who were in front of the court. Giving us some more details on this, our early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate our understanding of equity. You can't go outside the parties in the court. Been doing this forever. A 1975, 1890, referencing a case here. In fact, universal injunctions never even existed until federal court litigation happened sometime in the 20th century. So 1900s, we see the DC Circuit issued what some regard as the first universal injunction from the Supreme Court in 1963, when a bunch of other big changes came down. But those injunctions remained rare until the turn of the 21st century, when their use gradually accelerated. In fact, one study identified approximately 125 of these crap injunctions between 63 and 2023. But then 96 of them, over 3/4, were issued during the administrations of Bush, Obama, Trump, and Biden. 96 of them. The universal injunction was conspicuously non-existent for most of our nation's history. And Clarence Thomas has made this point before. He's like, we got through the entire civil rights era without universal injunctions. Its absences from the 18th and 19th century equity practices settles the question of judicial authority. We never had it before, so we don't have it now, says Amy Coney Barrett. Now, that the absence continued into the 20th century renders any claim of historical pedigree still more implausible. If we get our powers in equity from those old courts of equity, then we have to still exercise the same powers they have, unless some other law gives us permission to change it, and none do. Even during the deluge of constitutional litigation that occurred in the wake of Ex parte Young, another case, universal injunctions were nowhere to be found. Had federal courts believed that they had this tool, well, they would have used it. We had some major cases, like in the Lochner era, where the court could have come down and said, oh, universal injunction. Like, you just thought that all the other judges missed this power for the last 200 years, and no other judge could have, issued an injunction against somebody in the Civil War era? Actually, no. Faced with this timeline, the principal dissent accuses us. This is Ketanji and Sotomayor right here. Accuses us. Amy Coney Barrett blasting Sotomayor. I think you could say that the Girl Squad that some people were concerned about might not be happening anymore. Amy Coney Barrett's not invited to Farkle night over at the Sotomayor household. Not so. Saying we have a misunderstanding of the nature of equity, but not so. We said it before and we say it again. Equity is flexible. Now, at the same time, its flexibility is confined within the broad boundaries of traditional equitable relief. A modern device need not have an exact historical match, but under other case law, it has to have some sort of antecedent. You can't just make it up. And neither the universal injunction here or elsewhere, nor a sufficiently comparable predecessor was available ever in the court of equity at the time of our country's inception. No one had that power because the universal injunction lacks a historical pedigree. There's no basis for it. It falls outside the bounds of our equitable authority under the Judiciary Act, and the courts don't have this power. Now, they raise several counter arguments, which the dissent echoes, but first, they insist that the universal injunction does have a historical analog. They say, actually, in England, they had a decree resulting from a bill of peace, something very similar. And second, they maintain that universal injunctions are consistent with the principles that the courts of equities had, that you can now fashion complete relief. And third, they say that universal injunctions injunctions serve important policy objectives, right? So there are 3 objections. Amy Coney Barrett, gonna knock them out one after another. She says, well, here's what they're trying to do. There's this other case called Grupo Mexicano, and they have this historical test that came out of that case. And in that case, they said, well, a universal injunctive relief does have a founding era forbear. They said, well, it's kind of like a bill of peace. This bill allowed, back in England, the chancellor to consolidate multiple suits that involved common claims and plaintiffs that have multiple defendants. Kind of sounds like a class action. But she says this analogy doesn't work here. What they did back there was meaning to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. But even so, it was still the parties who were in the group. Their use was confined to limited circumstances, and they weren't allowed to just go get everybody like all the barbarian hordes are now approved. Unlike universal injunctions, Amy says, which can reach anyone affected by executive action, no matter how large the group is or how tangential it is, or whether they're MS-13 gangbangers or whatever, doesn't matter. A bill of peace involved a group that was small and cohesive, not an entire country. And the bill of peace actually does live on in modern form, but it's not a universal injunction, so you can't say we have that power there. It evolved into the modern class action, which is governed by Rule 23 of Federal Rules of Civil Procedure. And so there is an analog, but it's not what you say it is. None of these requirements is a prerequisite for a universal injunction. And so the rules also on class actions also underscore a significant problem with universal injunctions. A properly conducted class action, which has also not happened. So this, I think, would be the response to that. Boasberg and all these people who certified classes, there's no commonality even between the class, because some people in the class are making the allegation that they don't belong in the class. A properly conducted class action means you actually have to follow the rules. One of them says only if these factors are met can a class be certified. And a taxpayer lawsuit is also a bad analogy as well. And so that is not a valid argument. Saying that they are placing much, if any, reliance on taxpayer lawsuits as justification for the modern injunction is not appropriate. It's not the same type of claim at all. Now, respondents, the CASA and the illegal lovers, they contend that the universal injunctions, or at least these injunctions, are consistent with the principles of equity. It says we can do this. We have a lot of power in equity. Amy Coney Barrett writes, well, we agree that the complete relief principle does have deep roots in equity, but to the extent that you argue that it justifies an award of a relief to people who are non-parties to this case, they are mistaken. Now, Justice Jackson in this footnote, it's going to get dunked on here in a minute, says for her part, thinks that the premise that universal injunctions provide relief to non-parties is suspect, in quotes, because in her view, non-parties may benefit from an injunction, but only the plaintiff gets the relief. Wow. Okay, so Ketanji is trying to split it. Well, so what if it's a good rule for you? If it helps other people, they're not a party to the lawsuit, so they're not getting the relief. They're just getting a kind of an independent benefit. She writes, the availability of contempt proceedings suggests otherwise. Consider the civil contempt context. Under the traditional principles of equity practice, courts may impose civil contempt sanctions to coerce a defendant into compliance without an injunction. So Amy Coney Barrett's going to come back on that. She writes, complete relief is not synonymous with universal relief, right? It is a narrower concept. The equitable tradition has long embraced the rule that courts generally may administer complete relief between the parties. While party-specific injunctions sometimes advantage non-parties, they only do so incidentally. Consider this case, writes Amy Coney Barrett. A nuisance in which one neighbor sues another. Some guy's blasting loud music at all hours of the night. Probably that shark song or something. To afford the plaintiff complete relief, the court has only one feasible option. Order the defendant to turn her music down, or better yet, off, right? Of equity, this is unfair. I'm going to order you to be fair. Turn it off. Now, that order is also going to benefit the other neighbors too, who also don't want to hear that song. There is no way to peel off just the portion of the nuisance that harmed that one individual, right? Harms everybody. But while the court's injunction might have the practical effect of benefiting non-parties, that benefit is not merely incidental, right? It's not like another neighbor just gets no more music. As a matter of law, the injunction and its protection extends only to the suing plaintiff, as evidenced by the fact that only the plaintiff can enforce the judgment against the defendant responsible for the nuisance. So if the nuisance persists and another neighbor wants to shut it down, well, then she must file her own lawsuit. She doesn't get the benefit of the first neighbor who sued. Go file your own. The individual and associational respondents are therefore wrong to characterize the universal injunction as simply of an application of another complete relief principle. Under this principle, the question is not whether an injunction offers complete relief to everyone potentially affected by an alleged unlawful act. It's whether it applies to the plaintiffs, the people in in this court. Extending this injunction is to all other similarly situated individuals would not render her relief any more complete, talking about how this might impact a pregnant plaintiff. Her child, right here, if you prohibit the enforcement of Trump's order against the child of an individual pregnant plaintiff, will give that plaintiff complete relief, right? So if you're a pregnant mom, you're like, I want my kid to have citizenship, you can sue, make your claim. Her child will not be denied citizenship. Extending the injunction to cover everyone else, though, would not render her relief any more complete. Okay, so she's satisfied in her case. In this case, the complete relief inquiry is even more complicated for state party respondents because the relevant injunction does not purport to directly benefit non-parties. Instead, the District Court for Massachusetts decided that a universal injunction was necessary to provide the states themselves, right? The states now need a benefit. It's not just the mom and the baby, it's now the state. Now, as the states see it, they say, well, we get a bunch of benefits from having a bunch of citizens. Children often move across state lines. It's going to be very difficult for us to track all this, and so we're going to be harmed. Now, the government says that's ridiculous. You guys can handle citizens and moving. You can have people moving. The government, unsurprisingly, sees matters differently. It retorts that even if the injunction is designed to benefit only the states, it is more burdensome than necessary to redress their harms. They're getting a lot of benefits. After all, they say the court can award complete relief. Even though you can, doesn't mean you should. Now, we decline to take up these other arguments, says Amy Coney Barrett. Leaning on these principles, the government also says a narrower relief is required. For instance, they said that the district court ordered the government, forbidden the government, and other respondents within the states to do certain things, but we're not going to take those arguments up here, and so we're going to leave it to the lower courts to determine whether a narrower injunction is appropriate for these people in these circumstances related to this case. Now, respondents also defend universal injunctions, right, the CASA people, as a matter of policy. They say, well, if you just get rid of all these babies and just like divest them of this forthcoming citizenship, then we'll have major consequences. Writing, they argue that a universal injunction is sometimes the only practical way to quickly protect groups from unlawful action. Sotomayor wrote about it too. Respondents also contend that universal injunctions are an appropriate remedy to preserve equal treatment from Sotomayor. And they suggest that forcing plaintiffs to proceed on an individual basis, like you gotta sue on your own, can result in confusion or piecemeal litigation. And so one judge should be able to set policy for the entire state. And so they insist universal injunctions must be permitted for the good of the system. Amy says no. The government advances policy arguments that run the other way, right? Echoing Chief Judge Sutton, the government says that avoiding patchwork enforcement is a justification that lacks a limiting principle. And that means nationwide injunctions would be the rule of law rather than the exception. Congress wants to make some policy changes and then go make the changes in the law. It stresses, as the principal Dissent also observes, the universal injunctives and injunctions incentivize forum shopping, going to your specific favored judges to get the outcome that you want, since a successful challenge in one jurisdiction entails relief nationwide. In a similar vein, the government also says universal injunctions operate asymmetrically. A plaintiff only has to win one and they get relief across the entire country, but the defense has to fend off every injunction everywhere, and all the lib hack judges who came from foreign countries, many of them, and just got appointed by Joe Biden in his last amended term. Moreover, the government contends the practice of universal injunctions means highly consequential cases are often decided in a fast and furious manner, said Gorsuch in another case. And when a district court issues an injunction and halts the federal policy, the government says that it has little recourse but to proceed to the Court of Appeals for an emergency stay, and we've lived this for the last 6 months. Now, the upshot, as with most disputed issues, says Amy Coney Barrett, there are arguments on both sides. But as with most questions of laws, the policy pros and cons are beside the point. It doesn't really matter if you think it's like, oh, it's so harmful. What does the law say? Under our well-established precedent, equitable relief that was available to the federal courts is that same that was traditionally accorded to our courts of equity at the time of our founding. And there were no nationwide injunctions at the time. Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue these injunctions. Now, the principal Dissent and Judge Jackson, about to get blown out here, Amy says, the principal Dissent focuses on conventional legal terrain, like the Judiciary Act of 1789 and our cases on equity. But Justice Jackson, however, chooses a startling line of attack that is tethered neither to these sources nor, frankly, to any doctrine whatsoever, waving away attention to the limits on judicial power as a mind-numbingly technical query. She says, this is so mind-numbing to go back back and look at the law. She offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy blush, because she loves her own self a lot. In her telling, the fundamental role of the courts, her language, is to order everyone, including the executive, to follow the law. Full stop. A lot of people say that these days. No, full stop. No, we got you. We got what you're saying here. Order everyone, including the executive, to follow the law. That's what they say. Follow the law. According to them, their interpretation of the law. And when it's complicated, it's mind-numbing. And it's so technical for Ketanji. She'd rather just blab more than everybody else. She writes, the function of the courts, both in theory and in practice, necessarily includes announcing what the law requires in these lawsuits for the benefit of all who are protected by the Constitution, not merely doling out relief to injured parties. And she warns, if courts lack the power to require the executive branch to adhere to the law, courts will leave a gash in the basic tenets of our founding charter, apparently she's never read, that could turn out to be a mortal wound. So it's like poetry from like some lib blog. Got it. Now, rhetoric aside, says Amy, Justice Jackson's position is difficult to pin down because she doesn't really have one. She might be arguing that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. Like, what? Okay, so like always? Now, if that's true, then her position goes far beyond the mainstream defense of even universal injunctions. Like, nobody thinks that. Nationwide injunctions come with significant costs and should never be the default remedy in cases that challenge federal executive action. That's from a Law Review article. Now, as best we can tell, though her argument is even more extreme still, Ketanji just went nuts, because its logic does not depend on the entry of a universal injunction at all. In fact, Justice Jackson Ketanji, she appears to believe that the reasoning behind any court order demands universal adherence. What is her limit? At least when the executive is concerned. In her law-declaring vision of the judicial function, whoa, Amy! A district court's opinion is not just persuasive, but it has legal force of a judgment, right? And the executive must conform to that view and the law against anyone, anywhere, says Ketanji. Now, think about what this position means, says Amy, not happy. If a judge in the District of Alaska holds that a criminal statute is unconstitutional, can the United States prosecute a defendant in Maryland? Perhaps Justice Jackson would say yes. It is hard to imagine anyone saying no. But why, on Justice Jackson's logic then, does it not violate the rule of law for the executive to initiate a prosecution elsewhere? So then are they breaking the law? Among its many problems, her view is at odds with our system of divided judicial authority to keep the power of these maniac dictators in robes pinned down. This court's rule identifies other bases for appeal. It is also in considerable tension with the reality that the district court opinions lack precedential force even vis-a-vis other judges in the same judicial district. So we're not even going to dwell on Justice Jackson's argument, okay? So pathetic. We're not even going to spend time on it, which is at odds with more than 2 centuries worth of precedent. How did you even get on the court? Gosh, not to mention the Constitution itself, which she's going to be screeching about, saying, net gashing our founding charter. We observe only this. Justice Jackson decries an imperial executive while embracing imperial judiciary. Dang, son. Amy, coming out. Not playing around, man. Uninvited. Amy says, no one disputes that the executive has a duty to follow the law. That's obvious. But the judiciary does not have an unbridled authority to enforce this obligation. You can't do whatever you want. In fact, sometimes the law even prohibits the judiciary from doing that. Going all the way back to Marbury versus Madison, very controversial case, 1803, concluding that James Madison violated the law, but saying the court lacked the jurisdiction to issue a writ of mandamus because I can't be forced to do it. We have judicial review, but the law says I can't do that thing. Now, Jackson is dissenting. She says, if courts do not have the authority to require the executive to adhere to the law universally, compliance with law sometimes becomes a matter of executive prerogative. Observing the limits on judicial authority, including as relevant here, are boundaries by the Judiciary Act. It's required by a judge's oath, Ketanji, to follow the law. But Justice Jackson skips over that part because analyzing the government statute involves boring legalese. Oh my gosh. She, quoting her at her dissent, she seeks to answer a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? Amy says, in other words, it is unnecessary to consider whether Congress has constrained the judiciary at all. What matters is how the judiciary may constrain the executive. Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. And that goes for judges too, Ketanji. Finally, the government must show a likelihood that it will suffer an irreparable harm. And when a federal court issues a universal injunction against the government, it improperly intrudes on a coordinate branch of the government, and it prevents the government from enforcing its policies against non-parties. That's enough. The fact that the federal government is being stopped is enough. Now, the principal dissent disagrees, insisting that it strains credulity to treat the executive branch as harmed on this, says by these injunctions, even if they are overly broad. But that is, the Sotomayor says, because the executive order is unconstitutional. And so the executive branch has no right to enforce it against anyone. Now, the dissent's analysis from Sotomayor of the executive order is premature, right? The birthright citizenship issue is not even before us, Sotomayor. The dissent worries that the challenge will never reach this court because the plaintiffs will prevail individually, and they're not going to want to petition this up. So even if the government keeps losing, they're going to have no incentive to file a petition and whatever. She says, look, because the birthright citizenship issue is not before us, we're not even going to take a position on their dissent as to that. They're wasting a lot of time on an issue that is not even before the court. The dissent is wrong to say, however, that a stay applicant cannot demonstrate irreparable harm, and they can sue individually. But even her analysis on that is wrong too. Now, the question before us today, not that, is whether the government is likely to suffer irreparable harm when district courts exceed their authority. The answer is yes. If you can't do your job in the government, that is a harm. Now, some say that universal injunctions give the judiciary a powerful tool to check the executive branch. But federal courts do not exercise general oversight of the executive branch. Never have, never should, because that would make them superior, and they're not. They resolve cases and controversies consistent with the authority that Congress has given to them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. The government's applications, concludes Amy, to partially stay the preliminary injunctions are granted. Victory! But not only to the extent that the injunctions are broader than necessary to provide complete relief with standing to sue. The lower courts shall move expeditiously to ensure that, with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with the principles of equity. And you stop doing what you can't do. The injunctions are also stayed to the extent that they prohibit executive agencies from developing or issuing public guidance about the plan to implement the order, right? So Pam didn't have a lot of good answers on like how this was all going to work today. That's because they can't work on it. Judges said, no, you can't even begin to plan for this stuff. Now they can. Consistent with this representation of the executive order, it shall not take effect until 30 days after the date of this opinion. So also, right, they said 30 days, and so the court is pushing it back another 30 days. It is so ordered in a 6-3 decision. So that was a very nice decision, but we're not done yet. We got some other great ones that came down. Judge Clarence Thomas, writing his concurring opinion in the Birthright Citizenship Universal Injunction case. Clarence Thomas, with whom Judge Gorsuch came out, writes the following. The court today holds that federal courts may not issue so-called universal injunctions. Clarence says, I agree, and I join in full. And as the court explained, Amy did a nice job, the Judiciary Act of 1789, the statute that authorizes federal courts to issue equitable remedies, does not permit universal injunctions. It's very simple. It authorizes only those remedies traditionally available at equity. And there is no historical tradition of allowing courts to provide relief that extends beyond the parties, period. And that conclusion is dispositive. Don't need to go through other analysis, all right? Don't need to go into all the things that Amy Coney did. It's done. Now, as I have previously explained, if the district courts have any authority to issue universal injunctions, they have to find where that power comes from. Does it come from the law, statute, or does it come from the Constitution? Not. If it doesn't, then it doesn't exist. But the judiciary is the only real possibility because there is no other power, and serious constitutional questions would arise even if Congress did to one day allow universal injunctions. So I write separately, says Clarence Thomas, to emphasize the majority's guidance regarding how courts should tailor remedies specific to parties. Courts, like you, Zenas and Boasberg, must not distort the rule that injunctive injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. So if illegals sue Trump, the remedy against Trump satisfies the illegals in the lawsuit, not the entire country. Otherwise, they risk replicating the problems of universal injunctions under the guise of granting complete relief. So we've got equitable powers, remedial powers, and many other powers. So don't try to use this remedy power to do this either. As the court recognizes, the complete relief principle operates as a ceiling, and in no circumstances can a court award relief beyond that necessary to redress the plaintiff's injuries, right? So he would go further. Amy's a little bit kind of leaving open a little bit. Maybe there are some remedial powers out there. We don't really know. But Clarence Thomas says no. This limitation is obvious. It comes from Article 3 and from traditional equitable practice. Article 3 is specific. The Constitution limits courts to cases and controversies, saying that any remedy must be tailored to redress the plaintiff's actual injury, the people who sued. Now, and equitable remedies also, like even before we got this stuff codified into statutes, even before, like in England and the UK, they had plaintiff-specific bases of remediations. Now, courts therefore make mistakes and error insofar as they treat complete relief as a mandate. Some judges have read our cases to suggest that courts should provide relief and whatever remedy is necessary to give them complete relief. But that reading misunderstands the principle. The principle is that courts of equity may administer complete relief between the parties. It's not complete relief to the whole country. And as the court today affirms, any relief, says Clarence Thomas, must fall within the traditional limits on a court's equitable powers. And what they've done is far beyond that. Does it come from the principles of equity or not? This court's decision in other cases also exceeded the government's authority, and all indivisible remedy is appropriate, and indivisible remedy is appropriate only when it's all but impossible to devise some other relief. So there are major limitations on the equitable powers. Even if you interpreted them more broadly, they're just not broad at all to what they're saying it is. For example, the court today readily dispatches with the individual and the other respondent's position that they require a universal injunction because the court recognizes prohibiting enforcement of the executive order is all that is required to give the plaintiff complete relief, right? So if you're an illegal suing, you can get everything you need in your lawsuit from your judge. So for good reason, Thomas says, the court today puts an end to the increasingly common practice of federal courts issuing universal injunctions. The court also makes clear that the complete relief principles provides a ceiling on the authority, but you can't use your remedial powers either to go beyond the decision. Lower courts should carefully heed this court's guidance. Spoiler, they won't. And cabin their grants of injunctive relief in light of historical limits. If they cannot do this, the court will continue to be duty-bound to intervene. Talking to you, Judge Boasberg. Jeb, Justice Alito came in. Alito writes, I join the opinion of the court today, but I want to make a separate point. To note two related issues that are left unresolved and potentially threaten the practical significance of today's decision, which is another big problem that they're going to exploit. The availability of third-party standing and class certification. First, the court does not address the weighty issue. Whether the state, like Alito saying, we should have addressed a bunch of other things. Why are they suing in the first place? How can some third party sue under the Citizenship clause saying that they have a right to file a claim? Ordinarily, in our law, a litigant must assert his or her own legal rights. Like, why is CASA suing on behalf of the illegals and cannot rest a claim on others? In limited circumstances, we have allowed third party standing. Admittedly, the court has not pinned down the precise circumstances on this. Like, our case law is very problematic, as we've talked about. We don't really know. But at a minimum, we have said that a litigant seeking to assert legal rights of others must demonstrate ordinary Article 3 standing for themselves. So like if someone's going to stand in for someone else, they must have standing themselves. And they must answer at least another threshold question about whether they have the rights on behalf of others to raise standing for them. Now, this latter requirement, says Alito, as we have explained, entails a showing that the litigant has a close relationship to the right holder. There's some kind of hindrance there, like they can't do it for themselves. So long as third-party standing remains good law, federal courts should take care to apply these limitations conscientiously. Don't allow other people who are not parties to the lawsuit to come in, including against the states when the states are suing. That is especially so in cases like this one, where parties claim third-party standing, and they are not directly subject to the challenge policy in relevant respect and face at most collateral injuries. So Alito says, today's decision only underscores the need for rigorous and even-handed enforcement of third-party standing limits. The court today holds that this relief should generally extend only to the suing plaintiff, and that's going to have a salutary effect of bringing an end to this practice of universal injunctions, but they're just going to find other escape hatches, Alito Alito. He's kind of telling them what's coming. Perhaps most important, when a state brings a lawsuit to vindicate the rights of individual residents and then procures injunctive relief, does that injunction bind the defendant with respect to all the residents of the state? So somebody sues a state, gets an injunction, state loses. Does everybody in the state get the benefit of that? If so, states will have every incentive to bring third-party suits on behalf of their residents to obtain broader scope of relief than any individual could get when they sued on their own. Okay, so like states have special standing, I guess, so the states can sue themselves? Left unchecked, the practice of reflexive state third-party standing will undermine today's decision. And second, Alito says, today's decision will also have very little value if district courts award relief to broadly defined classes without following the class certification procedures. Commonality, numerosity, typicality. The class action is a tool. You have to certify them. They're certifying class actions for gangbangers who are not even common of a class because they've got different claims about why they don't belong in that class. These requirements are more than a mere pleading standard. Putting the kibosh, says Alito, on universal injunctions does nothing to disrupt the rule's requirements. Rule 23 may permit certification of nationwide classes in some discrete scenarios, but district courts should not view today's decision as an invitation to certify nationwide classes without scrupulous adherence to Rule 23. And they don't have hearings, they don't really do any investigation into the class before certifying them. Otherwise, the universal injunction will return from the grave under the guise of nationwide relief. And today's decision will be of little more than minor academic interest. Okay, so that's the risk. Lax enforcement of the requirements for third-party standing and class certification would create a significant loophole to today's decision. Federal courts should be vigilant against these abuses of these tools. I do not understand the court's decision to reflect any disagreement with these concerns, so I join its decision in full, right? So the court is not incorporating into its decision class action stuff or standing stuff. They're keeping their holding very narrow. But the other judges, Alito, Gorsuch, and Thomas, are hinting, and we're not seeing any rejection of any of these concepts by the majority. So it's a strong persuasive indicator to the other judges, stop certifying these nationwide classes. Stop giving people standing who don't have any standing. Coming from the majority. Kavanaugh also chimed in on this. He writes, the plaintiffs here sought preliminary injunctions to stop Trump's birthright citizenship problem. The district court granted a universal injunction, which says injunctions that prohibit the enforcement of the executive order against anyone. Kavanaugh explains, under the holding today, district courts issuing injunctions under the authority afforded under the law may only award plaintiff-specific relief. And I join the court's careful and persuasive opinion, which will bring clarity to these decisions. So why are you writing? But more importantly, today's decision will require district courts to follow proper legal procedures when awarding relief. District courts can no longer award preliminary nationwide or class-wide relief except when the relief is legally authorized. So Kavanaugh also coming in saying no to the class stuff. And that salutary development will help bring substantially more order and discipline to all this preliminary litigation over new federal statutes and executive actions. So I write separately simply to underscore that this case focuses only on one discrete aspect of preliminary litigation relating to major new federal statutes and executive actions, namely what district courts may do, not like the Supreme Court, with respect to those new statutes and executive actions in what might be called the interim before the interim. Although district courts have received much of the attention and criticism in the debates over universal injunction issues, those courts generally do not have the last word when they grant or deny preliminary injunctions. They're district courts. The courts of appeals and this court can and regularly do and expeditiously review district court decisions awarding this type of relief. The losing party will often go to the Court of Appeals, and the losing party may promptly come to this court. And we are the ultimate decider, not the district courts. Now, after today's decision, that order of operations will not change, right? The injusticiable cases, this court, not the district court, will be the ultimate decision maker of what the law is and not you. And so this decision focuses on the interim before the interim. And the question itself is immensely important. Whether a major new federal statute or action is enforceable. The status in turn raises other questions about whether there should be nationally uniform rules and more. He says today's decision, Kavanaugh wrapping up, on district court injunctions will not affect this court's vitally important responsibility to resolve applications for stays or injunctions. Like, we're still going to have to resolve these things. Deciding those applications is not a distraction from our job. That's also kind of a dig, I think, at Ketanji. It is a critical part of our job. With that understanding, I join the court's opinion opinion in full. All right, so we got Sotomayor. She's joined by Kagan and Jackson. Kagan, as we saw not long ago, actually agreed that universal injunctions were bad when they were being used against Joe Biden. But we saw that even Amy Coney Barrett did pay some respect to Sotomayor, saying at least Sotomayor tried to look at some case law like Dred Scott and the government and more. Justice Jackson says, I agree with every word of Sotomayor. They're going to go get drinks tonight. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. So Ketanji says, it is important to recognize the executive's bid to vanquish the so-called universal injunctions is at bottom a request for this court's permission to engage in unlawful behavior. It's like a blog. When the government says do not allow the lower courts to enjoin executive actions universally as a remedy, what it's actually saying is that the executive branch wants to continue doing something that is illegal. That is some solicitation. With its ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny this. Wild. Now, simply, she says, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions, unless you're a judge. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. This is constitutionally illiterate. To conclude otherwise is to endorse the creation of a zone of lawlessness within which the executive has the prerogative to take or leave the law as it wishes. No. If the president does something illegal, then Congress can impeach him and remove him from office. Don't you understand that? Where the individuals who would otherwise be entitled to the law's protection become subject to the executive's whims instead. No. It should be Judge Boasberg from DC who gets to decide. The majority, says Ketanji, cannot deny that our Constitution was designed to split the powers of a monarch between the government branches to protect the people. Oh my gosh, let's see what she says. Nor is it debatable that the role of the judiciary is to ensure fidelity to the law. But these core values are strangely absent from today's decision. Focusing on inapt comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and the law. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous, since it gives the executive the go-ahead to sometimes wield the kind of unchecked arbitrary power that our founders crafted to eradicate. The very institution of our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug and turn their backs to intermittent lawlessness with deep disillusionment. I dissent. She's gone just totally nuts. To hear the majority tell it, this suit raises a mind-numbingly technical inquiry, which you're a Supreme Court judge, right? That's what you were supposed to do. You're actually supposed to be the best in the entire world. Are universal injunctions sufficiently analogous to the relief issued by England? In England? Or do they fall within the Judiciary Act of 1789? But that legalese is a smokescreen. It obscures a far more basic question of enormous and legal practical significance. So whatever you need now, it matters more than what the written law says. May a federal court in the United States of America order the executive to follow the law? A lower level district court judge is how she's rephrasing this. Like, it's totally dishonest too. So to ask this question is to answer it. In a constitutional republic, a federal court has the power to order the executive to follow the law, and it must. It is axiomatic that the Constitution of the United States and the statutes the people have enacted govern our system. Thus, everyone from the president on down is bound by the law. No one is saying they're not. By duty and nature, federal courts say what the law is if there is a genuine dispute and require those who are subject to the law to conform their behavior to what the law requires. This is the essence of the rule of law. Don't take my word for it. Other figures in the nation have said it. So she's going to go out and give us a bunch of platitudes. Leave to live by no man's leave underneath the law. Well, this sounds like mind-numbing quotes here, Ketanji. What's your problem? Why are you giving us all these copy and pasted quotes? Those who birthed our nation limited the power of the government to preserve freedom. And as they all knew too well, Montesquieu, founders, human ambition, bunch of platitudes. Oh, she's going to cite Federalist 51, one of my favorites. Says the distribution of power between the judiciary and the executive is of particular importance. So she's going to lecture us about separation of powers now. Let's see how she botches this. Made up of free, impartial, and independent judges that she thinks she is, the judiciary checks the political branches of government by explaining what the law is and securing obedience to it. She cites a Supreme Court case. The federal courts were thus established not only to decide upon the controverted rights, but also upon the rights in controversy between them and the government. And quite unlike rules of kings, king's governing systems, every act of government may be challenged. And so in this country, the executive does not stand above or outside the law. Again, no one is saying that they are. We're saying a district court judge doesn't have the right to call it a violation of the law for the entire country. That's the point. She's arguing about something that is not even being argued. Consequently, when courts are called upon to adjudicate the lawless actions, we play an essential part of the democratic process. And so now with all that, I'm going to turn to this lawsuit. The majority now does what the lower courts wouldn't do. It allows Trump's birthright citizenship mandate to go into effect with respect to anyone who is not already a plaintiff in one of the existing actions. So now she's very mad about the birthright effect. Notably, the court has not determined that any of the lower courts were wrong or likely violated the Constitution. They didn't ask us to rule on the lawlessness of the executive order. They just said your injunction is overbroad. Now, as I understand the concern, and Ketanji definitely doesn't understand anything in this case, in this clash over the respective powers of two coordinate branches, the majority sees a power grab, but not by a lawless executive. Instead, she says it's the district courts. I can't even believe she wrote this in here. In the majority's view, federal courts only have the power to afford the plaintiff complete relief, only the parties. But so many questions arise. The majority's analysis is fully interrogated and countered. Sotomayor did it. And so my only objective is to write a blog about this, is to expose the core conceptual fallacy underlying the majority's reasoning, which to me also demonstrates why this is threatening to American rule of law. The founders of America rejected a king, and so we should have judicial kings now. Put differently, the majority views the power from the judiciary as an aperture that is very small. Federal courts do have small power, but reading this opinion, there's a foundational mistake, and she just keeps going, man. Do remember, the executive has not asked this court to determine whether the law is valid, and with its ruling today, the majority endorses the creation of a rule and a decision that has no effect, ultimately. I am not the first to observe that a legal system that operates on two different tracks is anathema to the rule of law, and consequently, this is a zone of lawlessness. The majority has now authorized a decision that will disproportionately impact the poor, yeah, got it, the uneducated, and the unpopular, those who may not have the wherewithal to lawyer up, and will all too often find themselves beholden to the executive's whim. Well, should have broken into the country. In the end, though, everyone will be affected because it's underhanded, and this skips over the consequences. They don't care. It's not, we don't care about the consequences. If you want to deal with the consequences, change the laws. You don't get to pervert the law because the consequence of that law is bad. Go change the law. Otherwise, you have a city of lawlessness that doesn't have laws at all. No one denies that the power of federal courts is limited. You do. But the majority seems to forget that the Constitution and Congress also limit the power of the executive. Yeah, we know that. And when you think there's a violation of that, then you can have the Supreme Court say it, not a district court, or you can impeach the president. In addition, it is indisputable that the executive power can leverage force and more. And so the bottom line is this: if courts don't have the authority to require the executive to follow the law universally, a dual track system develops and some people are going to get harmed. And man, she's just still on her little screed here. Or consider it the other way. When a court is prevented, another example from Ketanji, she just keeps going on. Make no mistake, today's ruling allows the executive to deny people the rights that our founders plainly wrote into the Constitution. Lie. So long as those individuals haven't found a lawyer. They never had that right. They never put in there illegal aliens could come in here and just have babies and call them citizens. Never. Not even under Juan Kim Ark. They were lawful permanent residents who were always here. Lawful and permanent. Get it through your heads. The perverse burden shifting cannot exist with the rule of law. In essence, the court has now shoved lower court judges out of the way, where in cases where they have no power. And that's right. And now these deportations will come back on, and the birthright citizenship stuff will be back in effect and start to be worked on. Perhaps the degradation of our rule of law would happen anyway, but I lament that the majority is caught up in the minutia of the government's self-serving finger-pointing arguments that it misses the plot. Man, no wonder Amy shredded her. Tragically, the majority also shuns this prescient warning. Even if such institutions may be destined to pass away, it is the duty of the court to be the last, not the first, to give them up. I don't even know what that means. Ketanji, one of the dumbest opinions we've ever read on this channel, rounding up this entire opinion. That's 119 pages. And Amy obliterated Ketanji. I was like, what set her off on that one? But we're glad that she did, because this dissent was pathetic. And she's evidently saying that she wants a supreme judiciary over the whole country, and Ketanji can just lead us all into hell. And we certainly do not want that.